from the report. It says, quote, "The evidence we obtained about the president's actions and intent presents difficult issues that would need to be resolved if making traditional prosecutorial judgments." So the bottom line is that they had difficulty establishing his intent. And they did note in the report, however, George, that the president took a number of, quote, unseen activities to influence or control the investigation. So that was Mueller's primary concern, that there was a lot of activity by the president that was meant to influence and control the investigation, that much of it was done in plain sight, and he had difficulty establishing intent. The other thing, in looking at the Volume 1, which deals with the obstruction of justice, I was struck by a number of things. It lists many of the names that we've heard before: Carter Page, George Papadopoulos, people like that, Paul Manafort. But it also makes clear that the Attorney General of the United States, Jeff Sessions, was under active investigation, and they considered whether to charge him with perjury. The other significant thing is that they spent considerable time looking at the Trump Tower meeting in June of 2016. They clearly wanted to establish whether that involved a violation of the law. Some facts that influenced their decision: number one, after that meeting, there was apparently no follow-up. The Russians attempted to reach back out to the transition team involving the Trump campaign, but the Trump campaign did not respond. There are some details in terms of why, specifically, that the Mueller team decided that they could not bring any charges in relation to the Trump Tower meeting, because, George, as you recall, that was probably the most overt action taken by members of the Trump campaign to get negative information about Hillary Clinton from Russians. Here's what the special counsel had to say about that. Quote, "Campaign officials or individuals connected to the campaign willfully violating the law basically would be difficult to improve that they had the intent to violate the law." Quote, it says, bear with me here, George, "On the facts here, the government would be unlikely to prove beyond a reasonable doubt that the June 9th meeting participants had general knowledge that their conduct was unlawful."
Right.
So basically,
that they knowingly and willfully violated the law. But there was an extensive section on that June 9th meeting. Of course, that was the meeting that Donald Trump Jr. had, where he had been told that they might be coming with emails related to Hillary Clinton. The other names, one of the names you didn't mention, they say that Jared Kushner, Paul Manafort, Eric Prince also had contacts as well. But Pierre, take a step back, because you've had a chance to spend a little bit more time with this than we have. One of the things we heard from the Attorney General, William Barr, is that this was likely, this was lightly redacted. We now know the report is about 448 pages. From your first reading through, could you tell how extensive these redactions were, and which one of those four categories, whether it was grand jury material, intelligence material, material affecting ongoing investigations, or material affecting individuals' privacy, do you have a sense generally of what kind of redactions we're seeing here?
Right. Many of the redactions I saw were related to grand jury. But, George, I have to tell you, there's not a lot of redactions in here. There's page after page after page where you're simply reading the material. There are some words redacted here and there, but, again, it's page after page after page, at least on the obstruction of justice section, Volume 2, where it is not redacted, George.
So and that's a key point there, because on the obstruction of justice section, Kate Shaw, almost all the information, if not all the information, that the special counsel developed on obstruction of justice was through interviews, not through a grand jury.
Right, and it seems like some of the evidence just came from public statements, right, which wouldn't have required any sort of sophisticated investigation techniques at all. So I'm too struck by the minimal redactions in parts of this report. There's very little that seems to be predicated on this personal privacy of third parties that we heard Attorney General Barr talk about. That struck me as the weakest legal basis on which to withhold when this report is in litigation. So I think that the Department of Justice has made the correct and cautious call not to overuse that basis for redaction. There is a good deal on ongoing matters. You know, we're all trying to figure out what.
Including the discussion of WikiLeaks, because, of course, Roger Stone, who is reputed to be in contact with WikiLeaks, that he's facing trial.
That's ongoing, right. So quite a big, sort of a few pages of fully redacted text in that section. But otherwise, I don't think we knew whether of these 400+ pages we were going to have, 100 pages of text or several hundred. And right now it does look like the redactions have not been excessive.
And John Carl, though, the clearest area so far of disagreement, and again, we're just beginning to read through this report, and we are going to take our time with this, and we're going to make sure we get it right. But I want to put up on the screen one more time. There's one clear disagreement between William Barr and Robert Mueller, and this is that sentence where Robert Mueller wrote, "If we had confidence after a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude that the president committed a crime, it also does not exonerate him." William Barr said he did not obstruct justice. Robert Mueller said we couldn't reach that judgment.
Absolutely, and in fact, George, Robert Mueller outlines here reasons, and we're still going through this, but reasons that there are significant concerns about the president's actions that would suggest possible obstruction of justice. So he is emphatic. He could not clear the president of this. He did not exonerate the president on the question of obstruction of justice. In fact, he found chapter and verse cases that raise serious concerns and questions about whether or not the president, in fact, obstructed justice.
And Mary Bruce, our senior congressional correspondent, Congress, as we said, now does have this report along with the rest of the public. I'm sorry, she's actually in the president's event right now. Terry Moran.
So as we go through it, we are confronted with, first, a lot of new information. The first thing to say is there's a lot of stuff that the public has not heard. Private meetings, comments by the president, and that in part goes to Attorney General Barr's notion that the president cooperated. He could have claimed executive privilege. He let his lawyer, his White House lawyer, spend hours with the special counsel. He didn't claim executive privilege. They turned over 1 million documents. So we're going to learn a lot, and some of it isn't pretty.
And one thing we talked about is Don McGahn, right? We've been talking about
the former
White House counsel, and what will he say? And this is page 113. The president orders McGahn to deny that the president tried to fire the special counsel. And then they give the background on what happened. In late January of 2018, the media reported that in June 2017, the president had ordered McGahn to have the special counsel fired based on reported conflicts of interest. McGahn had refused, saying he would quit instead. After the story broke, the president, I'm reading directly from the report, the president, through his personal counsel and 2 aides, sought to have McGahn deny that he had been directed to remove the special counsel. Each time he was approached, McGahn responded he would not refute the press accounts because they were accurate in reporting on the president's efforts to have the special counsel removed. The president later personally met with McGahn in the Oval Office with only the chief of staff present and tried to get McGahn to say that the president never ordered him to fire the special counsel. McGahn refused and insisted his memory of the president's direction to remove the special counsel was accurate. That's pretty damning stuff, just in terms of, again,
and what is the date on that again?
That's late January 2018.
So in shorthand, the president ordered his lawyer to fire the man investigating him, and then ordered his lawyer to say he didn't give that order. Now, if you're a prosecutor, that's something to look at, for sure.
Something to look at if you're a citizen.
If you're a citizen as well, that's where we are. Exactly. We are in the area where every single American has the right to look at this and make up their own minds about the president's conduct.
And of course, to see this was after some of the comments from the president, but the president consistently, when asked in the past and throughout 2017 about firing Robert Mueller, said, no, I'm not thinking about it at all.
Yes, but it was also sort of hard to gauge because he sort of seemed to waffle back and forth. There were days when he was furious with him, and then there were days where he seemed to say, like many and most in Washington did, that he was a reputable character. But you know, I mean, as we got closer to the release of the report last month, the president's attacks on Mueller became increasingly personal and, frankly, increasingly nasty. And they went directly after him. There was a long time where he never even named Robert Mueller in his Twitter account, and then just went full bore at him.
And even though after William Barr's summary, the president did say that Robert Mueller was an honorable man, and then continued the attacks in the days after.
And here's another overview, page 107, from the summer of 2017 through 2018. The president attempted to have the Attorney General Sessions reverse his recusal, take control of the special counsel's investigation, and order an investigation of Hillary Clinton. So you have another And again, that's not something that comes as a surprise, but it's something that was reported. And the question was, what do we know? How much do we know about it? And we now have the special counsel drawing that conclusion as well.
That was fake news, according to the President of the United States. It's now in the special counsel's report.
And those are two different things we're going to be looking at all day long as we go through this report. There was, as you said, Dan, a fair amount that already was in the public record. What does Robert Mueller ratify about what was already in the public record? And then what new facts did he uncover as we go along here? But Keisha, on the obstruction question, so much of this is going to be an interpretation of the law and Congress's responsibilities.
Right. So obstruction of justice was central to the impeachment, or the impeachment that never went forward, of President Richard Nixon, of President Bill Clinton. Obviously, obstruction was one of the charges that the House approved. So that has been central to previous episodes involving presidential misconduct. And, here we seem to have a prosecutor or special counsel concluding that there's a lot of evidence that seems to amount to something that looks like obstruction of justice. Does the conversation on the Hill change in that so far Speaker Pelosi has been pretty emphatic that impeachment isn't on the table? And I don't know. I think a lot will turn on the public's reaction to this, right? So the conduct that we're reading about has, implications in terms of its potential criminality, but also in terms of potential congressional responses. And I think that's connected to sort of how the public feels about the depiction of conduct that they're going to read about today.
And much of that will depend on what facts seep through to the public, which ones they seize on. Right. John Carl, you're also working on this one. We've been talking about Don McGahn, the former White House counsel, who we know spent multiple hours, at least 30 hours, probably more, with the special counsel. And he is clearly a central player in this report.
Absolutely. As mentioned, we see that the president directed McGahn to tell Sessions not to recuse himself and then to undo the recusal once he had. But if you look at this very interesting point where Don McGahn was directed by the president to do something that he felt would have been clearly obstructing justice, and refused. This is in the volume on obstruction of justice. On June 17, 2017, the president called McGahn at home and directed him to call the acting attorney general, and say that the special counsel had conflicts of interest and must be removed. McGahn did not carry out the direction, however, deciding he would rather resign than trigger what he regarded as a potential Saturday night massacre. And then, George, it goes on to describe the president's actions to try to enlist one of his prominent outside advisors to get involved in this effort. Corey Lewandowski, who for a time was, of course, the president's campaign manager, had a one-on-one meeting, according to this report, on June 19, 2017, in the Oval Office. And the president dictated a message for Lewandowski to deliver to Jeff Sessions, the Attorney General. The message said that Sessions should publicly announce that, notwithstanding his recusal from the Russia investigation, the investigation was very unfair to the president, and the president had done nothing wrong, and that Sessions planned to meet with the special counsel and, quote, let him move forward with the investigation into election meddling for future elections. Lewandowski was to deliver this message to Sessions, and he met with him, met again with the president the next day. The message had not been delivered. And according to this must come from Lewandowski's discussions with the special counsel. Lewandowski did not want to deliver the president's message personally. So he asked another White House official to do so. So you have cases here where officials in the White House, Don McGahn, outside advisor Corey Lewandowski, are being directed to take steps to essentially interfere with the investigation and are refusing to follow the president's orders.
So we know that the president, at times, he did remove James Comey. At times, he wanted to remove Robert Mueller and was complaining about his own Attorney General, Jeff Sessions. Chair Moran.
And this is something new. Another act that the prosecutors thought might be part of that tapestry that would amount to obstruction of justice. That the president, in March of 2017, met with the Director of National Intelligence, Dan Coats. This is on page 55 for those reading along at home. The president asked intelligence community leaders to make public statements that he had no connection to Russia. Coats says that the president never asked him to speak to Comey at all. But two named officials, who are Dan Coats, the Director of National Intelligence top aides, say that when he came back to his office, he said the president had said, is there a way that the intelligence community to get the investigation, get it over with, end it, or words to that effect. So this is the president now reaching out, according to the testimony of Michael Dempsey and Edward Gestaro, the president reaching out to the intelligence community saying, can you interfere with the FBI? That's what Nixon was impeached on in part, which was he was on tape saying, tell the CIA to tell the FBI to stop investigating Watergate because it'll get into national security meetings, issues. And here, at least on page 55, is the suggestion, not from Coates himself, but from Coates' two aides who said when he came back after meeting with the president, he said, the president wanted me to get involved in this FBI thing and there's no way I'm going to do it.
No way he's going to do it. Let's take a step back on the obstruction, because we now have the executive summary of the obstruction section as well, and it does lay out pretty clearly the 10 areas they looked at for obstruction that included the campaign's response to reports about Russian support for Trump. That, of course, deals with the president's response to WikiLeaks and the hacking. And it also points out, Cecilia Vega, that even though as late as 2016, the Trump organization had been pursuing a licensing deal for a skyscraper, that Trump Tower in Moscow, the president continued to deny any links or any contacts.
And we've known about that going in, and that's something that he's maintained all along. I'm also now reading, George, through some of the president's answers, presumably written in coordination with, if not by, his legal team to the direct question that Robert Mueller and the investigators posed to him. And they're going through all of these point by point, talking even in great detail about, you'll remember that speech from the campaign trail when the president says, hey, WikiLeaks, if you're listening, which became a huge, a monumental, we didn't know at the time, a monumental phrase that we've now gone back to over and over. And he's saying, I have, that was made in jest, that I was joking, and that anybody who was watching me would have known. So as we pour through this, we're going to learn more and more about some of the intricacies and the inner workings of things like the Trump Tower meeting and the Moscow deal.
And one of the other things, Dan Abrams, that is explained here in the report is why Robert Mueller chose not to push that issue of actually interviewing the president and accepting those written responses.
That's right. And, you know, the question was, is he going to be relying on a sort of a technical Department of Justice guidelines issue, which is what targeted the investigation? That's not what I'm seeing here. What I'm seeing is actually just the amount of time it would take and the delay that
and he thought he could get what he needed.
Yes, exactly, from other witnesses and other people. So he, in the end, didn't feel that it was necessary and worth, in effect, the amount of fighting that would have had to ensue and time it would have taken to get the president to answer those questions. I am seeing something additional here about the president's answers or lack thereof on certain questions about Michael Cohen.
Right.
It says on September 17, 2018, this office submitted written questions to the president that included questions about the Trump Tower Moscow project and attached Cohen's written statement to Congress and the letter of intent signed by the president. Among other issues, the questions asked the president to describe the timing and substance of discussions he had with Cohen about the project, whether they discussed a potential trip to Russia, and whether the president at any time directed or suggested that discussions about the Trump Tower project should cease, or whether the president was informed at any time that the project had been abandoned. On November 20, 2018, the president submitted written responses that did not answer those questions about Trump Tower Moscow directly and did not provide any information about the timing of the candidate's discussions with Cohen about the project or whether he participated in any discussions about the project being abandoned or no longer pursued. Instead, the president answers stated in relevant part, quote, I had few conversations with Mr. Cohen on the subject. As I recall, they were brief and they were not memorable. I was not enthused about the proposal, and I do not recall any discussion of travel to Russia in connection with it. I do not remember discussing it with anyone else at the Trump Organization, although it is possible. I do not recall being aware at the time of any communication between Mr. Cohen and Felix Sater and any Russian government official concerning the letter.
And of course, those words, I do not recall, are always the words that lawyers would have you use in discussions.
And the fact that the special counsel is saying he's not answering our questions. I mean, that's not my characterization. That's the characterization for the special counsel.
To me, that just really raises the question why they didn't push harder to interview him, right? So they could have tried to nail some of this down, I think, by actually having an in-person interview rather than relying on written responses, some of which are non-responsive. You know, and maybe the open question that might be presented if they are they'd have to maybe litigate it if the president didn't want to sit for the interview, and they didn't want to go to a Supreme Court and have this drawn-out, divisive fight about the president's ability to be, you know, compelled to testify against his wishes. And then if somehow they did get testimony from him, there's the possibility of perjury, right, which opens up a whole new front of kind of questions regarding the president's, you know, ability to be indicted for criminal conduct.
Which is, of course, what got Bill Clinton in trouble as well. Pierre Thomas?
Go ahead, George. I couldn't quite hear you.
No, you're weighing in now on the president's answers that we were just hearing Kate Shaw. Go ahead.
That's right. So the president was asked specifically about what he knew about the Trump Tower encounter with Don Jr., Paul Manafort, and Jared Kushner. And we're now seeing his responses for the first time. He says, quote, "I have no recollection of learning at the time that Donald Trump Jr., Paul Manafort, or Jared Kushner was considering participating in a meeting in June 2016 concerning potentially negative information about Hillary Clinton. Nor do I recall during the campaign that in June of 2016 that the meeting had taken place, that the reference emails existed, or that Donald Trump Jr. had other communications." So he's basically saying he did not know about it. That's what he's telling the special counsel. And then he also says, "I have no independent recollection of what portion of these 4 days in June 2016 I spent in Trump Tower." So he's saying that he has a very foggy memory in regard to that. And George, there's also some pretty interesting color that we found here about how the president first reacted when he was told that there was a special counsel investigation. He was apparently told by Jeff Sessions, and his quote was to the effect of, "Oh my God. This is terrible. This is the end of my presidency." That's according to one of the aides, George.
Yeah, that and also included something we cannot say right now on TV. I want to bring John Carl in for more.
I excluded that.
John Carl, for more on that right now. John, again, we have known from what the president has said in public, from the president's tweets, how angry he was about this. But we're seeing much more feeling now from inside the Oval Office, based in part on that extensive cooperation from the president's aides.
And what is significant about this is we learned that the president was in the Oval Office talking about potential candidates to replace James Comey as the FBI director. He was meeting with Jeff Sessions, the Attorney General, Sessions' Chief of Staff, Jody Hunt, and Don McGahn, the president's counsel, when Sessions got the phone call from Rosenstein saying that he had made the decision to appoint the special counsel. So it's when Sessions comes back into that meeting that the president has the reaction that you just heard from Pierre. This is the end of my presidency. And he goes on to say, this is the worst thing that ever happened to me. And during that meeting, he begins to tear into Jeff Sessions, the Attorney General, saying, "How could you let this happen, Jeff? How could you let this happen?" And he contrasts him to Eric Holder and to Robert Kennedy, who the president is saying, "You were supposed to protect me." The president is telling his Attorney General, quote, "You were supposed to protect me." So very interesting insight into the president's state of mind in those first minutes after learning that there was a special counsel.
George, here are a couple of critical paragraphs with regard to obstruction. One, this is page 157, that helps the president a little bit and understands why Barr made the comment he did in the press conference. It says, "In this investigation, the evidence does not establish that the president was involved in an underlying crime related to Russian election interference. But the evidence does point to a range of other possible personal motives animating the president's conduct. These include concerns that continued investigation would call into question the legitimacy of his election and potential uncertainty about whether certain events, such as advance notice of WikiLeaks' release of hacked information or the June 9, 2016 meeting between senior campaign officials and Russians, could be seen as criminal activity by the president, his campaign, or his family." On the other side of this, and this is, I think, one of the most interesting paragraphs in here so far, the president's efforts to influence the investigation were mostly unsuccessful. But that's largely because the persons who surrounded the president declined to carry out orders or accede to his requests. Comey did not end the investigation of Flynn, which ultimately resulted in Flynn's prosecution and conviction for lying to the FBI. McGahn did not tell the acting attorney general the special counsel must be removed, but was instead prepared to resign over the president's order. Lewandowski and Dearborn did not deliver the president's message to Sessions that he should confine the Russia investigation to future election meddling only. And McGahn refused to recede from his recollections about events surrounding the president's direction to have the special counsel removed, despite the president's multiple demands that he do so. Consistent with that pattern, the evidence we obtained would not support potential obstruction charges against the president's aides and associates beyond those already filed. So, in essence, what we're hearing the special counsel is saying is, boy, he was trying really, really hard, but the people around him weren't letting it happen.
And then the question is, what does Congress do with information like that, where they could look at that and say, listen, if the president's orders would have been carried out, that might have been a crime. Does it demonstrate an abuse of power? Does it demonstrate unfit for office, even if it doesn't reach that illegal bar?
And there is this line, this key line from the Mueller report. With respect to whether the president can be found to have obstructed justice, we concluded that Congress has the authority to prohibit a president's corrupt use of his authority to protect the integrity of the administration of justice. Now, they can do that by passing a law saying the president can't do X, Y, or Z, or they can do that after the fact by saying this pattern, and we're just beginning to learn about it, while it may not have risen to the level of a criminal charge of obstruction of justice, is clearly an effort by the person sworn to uphold the laws of the land to try to get people to help him subvert them. And if they decide that, then we're off to the races.
Chris Christie, one of the remarkable things here is how much we're learning from the president's aides.
Oh, it's absolutely right. And I think what you're seeing here is that the decision, the early decision by the president and his legal team to not claim any privilege and to allow everybody who the special counsel wanted to speak to, absent the president, to go and speak to the special counsel, that these people, it appears, were, from what we can tell from the early reading report, very candid, very direct about their interactions with the president, and that there was no attempt by these folks, at least as far as I could tell in the early reading of the report, to sugarcoat this stuff in any way.
Yeah, but to pick up on what Dan Abrams was reading there, though, they clearly were candid, as you say. That portrait of the president's aides not carrying out his wishes in a way that might end up protecting him from an obstruction of justice charge, pretty remarkable.
Well, it is, although I will tell you this, too, though, George. I think having been a chief executive in a state, that's part of what you count on your aides and the people around you to give you advice and to help you with. There are times when you're a chief executive, you're going to get emotional about certain things and say things, and your aides are going to come to you and say, listen, we can't do this, or you can't say that. I'm not saying that that ever really involves criminal conduct, as we see, eventual criminal conduct, as we see here. But I think what chief executives count on their aides to do is to be, an informing effect, a moderating effect. And I think that one of the things that is good to see in this report is the fact that all these people stood up to things that they thought would be questionable conduct and refused to do it. I think it says a lot for guys like Don McGahn in particular, who seemed to stand up to some particular pressure that came to him, and he didn't give in.
And John Carl, you're picking up more from inside the White House in the report?
I am. This is a section of the report, again, on the question of possible obstruction of justice. Recall that Rod Rosenstein was the person responsible for overseeing the special counsel investigation because of the Sessions recusal. And we have here a suggestion that there was a consideration to firing Rosenstein. Let me read to you this. Keep in mind the number 3 official at the Department of Justice at this time is somebody named Rachel Brand. So here we go. In early July 2017, the president asked Staff Secretary Rob Porter what he thought of Associate Attorney General Rachel Brand. Porter recalled that the president asked him if Brand was good, tough, and, quote, on the team. The president also asked if Porter thought Brand was interested in being responsible for the special counsel's investigation and whether she would like to be Attorney General one day. Because Porter knew Brand, the president asked him to sound her out about taking responsibility for the investigation and for being Attorney General. Contemporaneous notes taken by Porter show the president told Porter to keep in touch with your friend, a reference to Brand. Later, the president asked Porter a few times in passing whether or not he had spoken to Brand, but Porter did not reach out to her because he was uncomfortable with the task. In asking him to reach out to Brand, Porter understood the president to want to find someone to end the Russia investigation or fire the special counsel, although the president never said so explicitly. Porter did not contact Brand because he was sensitive to the implications of that action and did not want to be involved in a chain of events associated with an effort to end the investigation or fire the special counsel. So once again, a pretty glaring effort of the president asking a subordinate to do something that the subordinate feels would be either unethical or illegal. Rob Porter was the staff secretary. He was a friend of Rachel Brand over at the Department of Justice, and he refused to go and to deliver that message to Rachel Brand. And of course, in the end, Rosenstein's never fired. Rachel Brand is never put in charge of the investigation, and presumably not until now knew about this chain of events.
Yeah, well, go ahead, John.
One other thing in this section, which keeps coming up, is, again, Rod Rosenstein is in charge of the special counsel investigation because the attorney general has recused himself. And as we know, the president was furious about that decision. Here's something interesting from the testimony of Hope Hicks, another one of the president's close advisors, who freely met with the special counsel. Hicks said that the president viewed Sessions' recusal from the Russia investigation as an act of disloyalty. In addition to criticizing Sessions' recusal, the president had raised other concerns about Sessions and his job performance with McGahn and with Hope Hicks.
So one of the things clearly established by Robert Mueller so far, and we're just working our way through this 448-page report, is that on several occasions the president directed staff, encouraged staff to remove every single person in charge of the investigation at various times, whether it was the Attorney General, whether it was the special counsel, whether it was James Comey, the FBI director. I do want to take a step back right now and reset. Of course, the report was made public about 45 minutes ago, as we've said, 448 pages. It's divided into two main sections, looking at whether they could establish collusion with Russia, conspiracy with Russia, also obstruction of justice. As we've said, the special counsel himself did not draw any ultimate conclusions over the president's conduct on obstruction, though he clearly states that he could not exonerate the president. There's that quote right there. If we had confidence after a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. We also know that the Attorney General was investigated for potential perjury and that the president directed White House counsel Don McGahn to fire Robert Mueller. One of the other points he makes, and I want to go back, this goes back to the Michael Cohen section on obstruction of justice, and it's a pattern that Robert Mueller established, is that the president discussed pardons with the president's personal counsel and believed that if he stayed on message, he would be taken care of. But after Cohen began cooperating with the government in the summer of 2018, the president publicly criticized him, called him a rat, and suggested that his family members had committed crimes. This is something we saw often. We saw it with Paul Manafort. We saw it with Roger Stone. We saw it with Michael Cohen. The president thought witnesses were on his side. He praised them publicly. When he thought they were going in the other direction, he criticized them. And Robert Mueller is now citing this as well.
And honing in on that, which goes back to, I think, I would assume his confliction, self-confliction as to whether he could cite obstruction of justice for this against this president. I'm also still pouring through, George. I want to bring up to you the response from the president, and I apologize to our team because I'm not able to get the actual page here, but this is from the president. I'm just struck by the number of times that he and his team say that they do not recall in his written answers. They do not recall everything from talking about WikiLeaks. They do not recall everything from talking about things that we mentioned about Michael Cohen, about the Moscow Trump Tower deal. But this section in particular about Roger Stone, and I'm on the C addendum, I think, page 13.
This is all in the appendix.
All in the appendix, yeah, thank you. I spoke by telephone with Roger Stone from time to time during the campaign. I have no recollection of the specifics of any conversations I had with Mr. Stone between June 1st, 2016 and November 8th, 2016. that stretch of time, you can't remember one specific thing? I mean, you kind of scratch your head at that. I do not recall discussing WikiLeaks with him, nor do I recall being aware of Mr. Stone having discussed WikiLeaks with individuals associated with my campaign.
And a lot of that section also is redacted because some of that is grand jury material or is facing the continuing investigation of Roger Stone.
There's a portrait that's emerging of Donald Trump during these months from these pages. This is a man in a fight, and he is fighting like a beast. At the same time, he's won an election he probably didn't expect to win, and trying to do the hardest job in the world. And so you can look at this evidence of telling people, get this investigation away from me in two ways. And the country will. On the one hand, he's trying to subvert a legitimate investigation into an attack on our country by Russia and whether or not he or anyone around him participated, and he's trying to subvert that. The other way you can look at it is he's got the biggest job in the world to do. He is furious. He sees this as a political fight for his life, for his political life and maybe for his freedom, and he cannot believe that the people who work for him won't help him stop it so he can get on with what he was elected to do, the business of the country. That's the way this reported. That's the portrait that's emerging. A man fighting with fury, asking everybody around him, will no one rid me of this meddlesome investigation? And the question is motive.
Right. Well, but does the motive there really matter of whether he's protecting? I mean, in both cases, he still ends up protecting himself.
Well, but he has the right to discharge the duties of the president's office. And he took an oath to do it. And his lawyer at one point said the president can't obstruct himself. He is the administrator of justice. We have one president, right? And so the question is he trying to essentially say, guys, go look at some real crimes so I can get on with this business that I was elected to do? Or is he saying, I cannot let this investigation get any closer to me because they're going to catch me? And that's the question.
And I think, again, taking a step back as well, it does seem clear that on the issue of obstruction of justice, it was not inaccurate for the Attorney General Barr to say what he said in his letter about Mueller simply not being able to reach a conclusion. That has been borne out by what we see in the report.
Not being able to reach a conclusion that he did obstruct justice.
Correct.
He also says he could not reach a conclusion that he did not obstruct justice.
But that was that was in the letter that Barr provided as well. And, you know, the question that I had going into this was, how much is Mueller going to rely on, for example, Office of Legal Counsel, guidance on not indicting a sitting president? And it seems that it was really more simply based on his analysis of the law and the facts and how difficult obstruction can be, A, when you're the president, B, when you don't have an underlying crime, C, saying, look, I'm not saying that public acts can't be obstruction, but all of this together does not make for an easy obstruction case. Right. And I think that's an important sort of step back as to, you know, what these hundreds of pages of documents are saying about that issue.
And presumably, if and when Robert Mueller is called to the Congress, he'll be asked the direct question, what did you intend? Did you intend for this to come to us or not? And we'll hear that answer from him personally. John Carl, I know you've been combing through reporting. You've come up with something else you want to highlight?
Yeah, 2 points. One is my count so far, and again, we're still working our way through this, but I count 5 people close to the president who refused to follow the president's directives on issues that would have raised obstruction of justice concerns. And the list is pretty incredible here, George. First of all, obviously, Jeff Sessions refusing repeatedly to undo his recusal, and Mueller points out the reason why he wanted that was so that Sessions could constrict the investigation. Don McGahn, his White House counsel, repeatedly refusing to do things like fire the special counsel. Corey Lewandowski, as I described earlier, his former campaign manager, one of his most intensely loyal outside advisors, refusing to pass a message along from the president to the attorney general because he was concerned about the appropriateness of that message. Rob Porter, who interacted with the president as much as anybody in the White House before he was eventually fired, the White House secretary, staff secretary, refusing to pass a message to Rachel Brand. Rick Dearborn, one of the deputy chiefs of staff, also listed here as refusing to carry a message to Jeff Sessions. So here you have people, the people that are with the president, that are closest to the president, that are the most loyal to the president, refusing to carry out his directives because they felt, presumably, that these would be illegal. Really an extraordinary tapestry here looking at this. They may have protected the president from himself. If they had gone through with any of these, you know, the implication here is that there would be an obstruction of justice case. Now, George, one other thing is the question of the president's memory in those written questions. Mueller makes it very clear here that he wanted to interview the president in person. He writes, this is on Appendix C, the written responses, we informed counsel, demonstrate the inadequacy of the written format, as we have had no opportunity to ask follow-up questions that would ensure complete answers and potentially refresh your client's recollection or clarify the extent or nature of his lack of recollection. Then he writes, Mueller writes, we again requested an in-person interview limited to certain topics, advising the president's counsel that this is the president's opportunity to voluntarily provide us with information for us to evaluate in the context of the evidence we have gathered. Mueller says that he then, when he didn't get a yes answer, they considered whether or not to issue a subpoena for the testimony. And the reason, prominent reason, that Mueller did not go forward with a subpoena is that it would have dragged out the investigation.
It would still be in the
so
courts
it's very
today.
clear that the president, that Mueller wanted to talk to the president. The president had said publicly that he was willing to talk to Mueller under oath, but he steadfastly refused repeated efforts by the special counsel to interview him in person.
And that may have helped him. I want to bring in Tom Bossert, who also is the former director of Homeland Security inside the White House for President Trump. And I want to pick up on the previous point that John was making, that pattern of the president ordering, saying he wants actions from his subordinates to stifle the investigation, those individuals inside the White House refusing. I mean, you worked inside of the White House. You worked closely with President Trump. Does it ring true to you?
Well, I mean, I guess it rings true to me that this president, I think it's no surprise, is pretty on his sleeve with his emotions. When he was angry, we knew it. When he was happy, we knew it. And when he wanted something done, he expressed it to us. But I guess what's not being said here is that he was also, whether it was in a grouchy or begrudging way or otherwise, willing to receive that advice that Governor Christie spoke of. So it wasn't always welcome when we pushed back and informed him that something wasn't legal or proper or effectable. He did it. You know, he said it and he asked us to do it. And then when he took advice back, he grumbled. But I think what we're seeing here today is the president was really well advised by a lot of people that probably deeply frustrated him. And he might not have been well advised by some people that were on his campaign in the beginning. And he just didn't know it at the time. So this is fascinating to read through. George, I have another observation here as I go through this with all the rest of us today. I'm struck that Director Comey kind of got us into this mess. I mean, the Russians got us into this mess, but Director Comey kind of started some of this for us by making a prosecutorial decision when it wasn't his role to do so with the Hillary Clinton emails matter. And now we have a special prosecutor who's given the express authority to prosecute crimes in his mandate from the Deputy Attorney General, who chooses, and it's pretty clear, he doesn't say why, but he says, we've chosen not to make a traditional prosecutorial decision here. I mean, the big question for me is why? You can't say because it was hard. There are theories as to why Director Comey made that decision at the time, and he's written about it in his book, so you can debate. But why would this special prosecutor choose to really take a pass on his
well, one of the big differences is, of course, Tom, thank you, is that, of course, that James Comey was not looking at the president of the United States then. He was looking at Hillary Clinton, and here the president of the United States was the subject. And Kate Shaw, you found another portion of the report directly on that point.
So in volume 2 on page 1, we actually do get to see what the special counsel made of this OLC position, that a sitting president can't be indicted. Honestly, it's a little confusing what it is they're saying. But basically, they say, we are part of the Department of Justice. We've accepted the Department of Justice's view that a sitting president can't be indicted. That said, there's nothing to prevent a sitting president from being criminally investigated. In fact, OLC has actually said that's okay. So we're doing an investigation. But we also determined not to apply an approach that could potentially result in a judgment that the president committed crimes. So they've decided from the jump that they can't conclude that he committed a crime, and yet they do this thorough factual investigation and don't rule out the possibility that he did.
Can you read that
it's a confusing
again?
sentence.
Yeah,
page 2 of volume 2. Page 2 of volume 2, which is the obstruction of justice portion. We considered whether to evaluate the conduct we investigated. This is the first full paragraph. Under the Justice Manual standards governing prosecution and declination decisions, but we determined not to apply an approach that could potentially result in a judgment that the president committed crimes. So we essentially decided before we started the investigation what we couldn't conclude.
Yeah, but we determined it there, but he actually doesn't say why they made that determination.
Well, then he goes on a little bit, and he says, here's a couple of things. One, fairness concerns counsel against potentially reaching that judgment when no charges can be brought, in part because if they say he committed a crime, but they can't charge him for it, he can't defend himself the way he could in court. Now, I think that misses the fact that the president has this bully pulpit he can use to defend himself, but that at least is the judgment that it seems that this very experienced team of prosecutors made, that so he can't be indicted, he can be investigated, but there's kind of these constraints on the investigation, which is that there's one conclusion: they don't believe they have the legal authority to reach. Now, tell me if you guys disagree with how I'm reading this, but I think that's what it says.
And he's basically saying that they're applying 4 factors, right, in terms of evaluating the possibility of obstruction of justice. And the fact that, 1.5 of them relate to the Office of Legal Counsel's view on a sitting president not being indicted, it is clear that was a factor in the way that they looked at the evidence here. Because it does say, second of the 4, we first described the considerations that guided our obstruction of justice investigation, and then provide an overview of this volume. And then number 2 is, while the OLC opinion concludes that a sitting president may not be prosecuted, it recognizes that a criminal investigation during the president's term is permissible. The OLC opinion also recognizes that a president does not have immunity after he leaves office. And if individuals other than the president committed an obstruction offense, that may be prosecuted at this time. Given those considerations, the facts known to us, and the strong public interest in safeguarding the integrity of the criminal justice system, we conducted a thorough factual investigation in order to preserve the evidence when memories were fresh and documentary materials were available. So basically they're saying, yes, the OLC says a sitting president can't be indicted, but that doesn't mean that we can't pursue this investigation.
Right, but and this is what's also significant here, and we're just going through this right now, is that was a significant part, Terry Moran, of Robert Mueller's judgment right there. But in fact, William Barr said that he disregarded that.
Right. He stepped right in and said there's no obstruction of justice crime here. Regardless of what he said. Well, this is a punt. I'm with Tom Bossert. You got hired essentially to make these decisions. You're the prosecutor. I'm not quite sure why. And reading between the lines, it looks like there was a disagreement on the team. There were some gung-ho prosecutors who thought they could move forward in this, and some who couldn't. And the solution was found in Watergate. Okay, so Watergate was the investigation of a president for obstruction of justice. Before the grand jury, the prosecutors in Watergate had presented it, and the grand jury named Nixon as an unindicted co-conspirator. So they got him in the conspiracy, but they didn't indict. Now that was secret, but it leaked months later. And there's a reference here. We didn't want to go that route because it would leak.
But hasn't the, and correct me if I'm wrong about this, but didn't this OLC interpretation of the law come out in the wake of Watergate?
Yes, and then it was reinforced during the Clinton investigations, where the sitting president, and this is a debate that's gone back to the beginning of the presidency, can't be indicted because you would disrupt the functions of the government too excessively. But you could either name him as an unindicted co-conspirator, but they should say at the end, we don't have the evidence for, we can't make the obstruction of justice charge here, or you could seal it, wait for the president to leave office, and then get
and this is a separate question, Kate Shaw, but it makes me think of the Southern District of New York, where, of course, Michael Cohen pled guilty on the campaign finance charges. President Trump is individual one in that case, directing Michael Cohen. If the Southern District prosecutors reach the same judgment as Robert Mueller did in paragraph 3, then they're not going to do anything.
I think that's right. I mean, the Southern District of New York has always been understood to sort of have this kind of peculiar autonomy from main justice. So if any part of the Department of Justice might break from that orthodoxy, I think it would be that office. But So far as we know, that's not possible. Criminal exposure of the president in the separate Michael Cohen matter doesn't seem like it's really on the table. But I do think that this framing really matters. The president in some ways had a massive advantage going into this investigation because there was one outcome that was totally off the table, which is that he committed crimes. The other outcome, that he didn't commit crimes, is something that the special counsel isn't willing to say. So in some ways, when you sort of look at the framework, this feels a lot less favorable to the president than the initial framing, both in the original Barr letter and in this morning's press conference.
Clearly seems to be a distinction there, and one of the questions is going to be what does the Congress do with it? It is now noon on the East Coast, 9 a.m. in the West. We want to bring you up to speed on where we are right now. About an hour ago, the Robert Mueller report, special counsel, was released to the public. It's in the hands of Congress now as well, from what we've seen so far. Almost 500 pages long, 448 pages, two big sections divided between collusion and obstruction of justice. Special counsel Robert Mueller did not draw an ultimate conclusion on obstruction of justice, did not say that the president was cleared, did not say that the president committed that crime. Quote, if we had confidence after a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. We've also gone through the parts of the report detailing that the president ordered several members of his administration to interfere with the investigation to get rid of individuals in charge of the investigation, including his White House counsel, Don McGahn, who ordered to fire Mueller. McGahn refused to do that. And we also know that the Attorney General, Jeff Sessions, was investigated for potential perjury over his congressional testimony as well. We now have our senior congressional correspondent, Mary Bruce, is back with us as well. Mary, the Congress has had now about 50 minutes or so, the Judiciary Committees, to digest this report. Any readings from them yet?
Well, George, what we are hearing so far, and they are still pouring through this report just like the rest of us, is that Democrats still are not satisfied. We are now seeing calls for Mueller to appear and testify on the Hill piling up. We have both the chairman of the House Judiciary Committee and now the chairman of House Intelligence, Adam Schiff, saying that Mueller needs to come and explain his report in his own words. And that's what you are hearing over and over again from Democrats, that what Barr has put out here, the redacted version, simply isn't going to cut it for Democrats. They are reiterating their calls for the full unredacted report, and they want the underlying evidence, even though Bill Barr has now said that he is going to provide some congressional leaders with an unredacted version with exceptions for grand jury material. That is not enough for Democrats. They've said they want the grand jury material. They want essentially all of the goods, and that nothing short of that is going to satisfy them. On the flip side, George, Republicans are saying that they are satisfied with the way Barr has handled this report and the investigation and the rollout of this today. They are hailing his transparency, and we are hearing from the top Republican in the House, Leader Kevin McCarthy, is essentially saying to Democrats, it's time to move on. Give this up. Democrats, certainly, from the looks of it so far, are far from doing that.
They're not ready to do that. One other point before I let you go, Mary. We also know that the Congress is going to get separate briefings that include some of the unredacted material. And, of course, the top congressional officials on intelligence matters can also get a secret briefing on which is kind of a separate strain of the Robert Mueller investigation. They're investigating their counterintelligence investigation into whether anyone in the president's orbit was compromised in any way.
Yeah, and of course they want all of these details, right? But that is still not going to be enough to satisfy Democrats when they say they want the full report and they want to be able to make as much of it public as possible. This gets to the underlying point that they want to see Mueller's true words here. They don't just want Barr's summary. That's not going to be enough. As Adam Schiff said in a statement just a short while ago, we have to get to the bottom of these things. As Adam Schiff said, that after a two-year investigation, the public deserves the facts, not Attorney General Barr's political spin, and nothing short of that's going to satisfy.
Mary Bruce, thanks very much. I also want to bring in our Chief Global Affairs Correspondent, Martha Raddatz, for more on this. And Martha, up until today, so much of what we learned about Russia came from the intelligence community, but also came from the indictments that Robert Mueller laid out before this final report. He's now filling in some of those details.
He is, and I think what we can't forget, what the Justice Department said about 2016 was that Russia had a very clear goal, and that was supporting the presidential campaign of then-candidate Donald Trump and disparaging Hillary Clinton. And today we learned more about that. We learned during the WikiLeaks dissemination of information about Hillary Clinton and her emails that earlier that day, and we're talking about July 27th, 2016, candidate Trump made public statements that included the following. Russia, if you're listening, I hope you're able to find the 30,000 emails that are missing. I think you will probably be rewarded mightily by our press. I think we all remember when candidate Trump said that. The 30,000 emails apparently a reference to those in media accounts that were missing from Clinton's emails. And this today in the Mueller report, within approximately 5 hours of Trump's statement, GRU, and that is the Russian military intelligence officers, targeted for the first time Clinton's personal office after candidate Trump's remarks. Unit 26165 created, that's the Russians, and sent malicious links targeting 15 email accounts at the domain, including an email account belonging to a Clinton aide. Now, there's also another interesting thing in here today. After candidate Trump stated on July 27th, which we just talked about, those 30,000 emails, that he hoped Russia would find the 30,000 emails that are missing, Trump asked individuals affiliated with his campaign to find the deleted Clinton emails. Michael Flynn, who would later serve as national security advisor in the Trump administration, and of course later pleaded guilty to lying, recalled that Trump made this request repeatedly, and Flynn subsequently contacted multiple people in an effort to obtain those emails. It also says, however, the investigation did not find evidence that the Trump campaign recovered any such Clinton emails or that these contacts were part of a coordinated effort between Russia and the Trump campaign. And as you know, George, we heard earlier Attorney General Barr say under applicable law, publication of these types of materials would not be criminal unless the publisher also participated in the underlying hacking conspiracy.
And thank you, Martha. And Dan, there seems to be sort of a parallelism here. On the obstruction cases, the president orders people to take action. They don't take it. That ends up protecting him. He wants all this material, but there's actually, it never comes, so he's protected by that as well.
Absolutely. I think it's a good point. I want to take one more step back, because I think it's important to supplement something I said before. We're now at the beginning again of the obstruction section, where it's the introduction, where Mueller lays out, again, I mentioned this before, but now I've been able to kind of make sense of it better. These 4 factors that he took into consideration in evaluating whether there's obstruction of justice. And when you look at them together, it's actually not good for the president. And here's why. Because he's basically saying he really did rely on the Office of Legal Counsel's conclusion that a sitting president can't be indicted. It starts with, this office accepted OLC's legal conclusion for the purpose of exercising prosecutorial discretion. Goes on. Second, while the OLC opinion concludes that a sitting president may not be prosecuted, it recognizes a criminal investigation is permissible. We talked about that. Number 3, in Section 3, fairness concerns counseled against potentially reaching that judgment when no charges can be brought. Again, sounding like what he's saying is, unless we really had it here, we weren't going to move forward. And that's kind of what he says at the end. It says, if we had confidence after a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. And so it's almost like they're reversing it. They're saying, we can't prosecute a sitting president. We know that. But we can still investigate a sitting president. But we're telling you right now, if we could clear the president based on the facts and the law, we would, and we can't. And so it's an interesting, almost a reversal of the standard here, in saying, if we could exonerate him, we would, but if we could implicate him, not sure that we would do that.
Well, beyond not sure, right? We wouldn't do it.
We wouldn't be able to bring charges.
Yeah.
But I think that they might have said that if it was clear that it raised the level of it would have been a crime. But I'm not sure, actually. I mean, it's sort of ambiguous, right?
It's a hard-to-parse section, and it's a really important one, so it's worth kind of trying to puzzle it through. But one way to read it, I think, is a compromise among competing teams, competing camps on the team, right? So Mueller has 20 very experienced prosecutors working for him, including arguably the best criminal lawyer in the country, who is on loan from the Solicitor General's office, and they're puzzling through it, and they maybe had different views about how strong the evidence was, and so they don't say the evidence rises to the level of a criminal action. This is a crime, but we can't indict a president, but they don't say it doesn't. And so it's this odd hybrid, answer that they seem to be giving. One way to understand it maybe is this is for Congress to look at, right? There's a lot of really troubling activity
But what's
here.
clear is they were not asking Attorney General Barr to weigh in. I mean, there's nothing in here which suggests, oh, you know what? And as a result, we're hoping that the Attorney General can decide for us.
Based on the same material that we've amassed, and not the personal kind of experience of 2 years of doing it.
And I think one of the areas, and I supported something that Barr said based on what we saw here, and I'm now going to say that there is information in here which I think undermines a little bit something Barr said, which is I think he minimized the Office of Legal Counsel opinion on not indicting a sitting president in a kind of unfair way. When you look at these 4 factors that go into evaluating obstruction of justice, and they all kind of relate in some way or another to the fact that a sitting president can't be indicted, according to the Office of Legal Counsel, that does become an important factor in the way that they looked at all the evidence in this case.
And Terry Moran, clearly the Attorney General said, well, listen, he's my appointee, so I'm going to step in. I have the right to do that. He also made the point when he was giving his press conference that Barr did not explicitly Mueller did not explicitly state that this should go to Congress. I guess the question would be, did he ask?
Did he ask whether or not it should go to Congress? And there is that line, which I noted earlier in the report, that we concluded that Congress has the authority to prohibit a president's corrupt use of his authority. And that in some ways is a suggestion that Congress can take a look at not just whether or not there is the violation of a criminal statute, but whether the president has corruptly used his authority. That's beyond the scope of the Department of Justice. Now, Barr felt perhaps that as the Senate confirmed Attorney General, as the constitutional officer responsible for prosecutorial decisions, he made the call. It's his call to make.
John Carl, one of the things that seems pretty clear when you put together what is in the report about the president's feelings about his previous Attorney General, Jeff Sessions, and what we're seeing from William Barr is in many ways the president...
I'm sorry, George, somebody was talking to me.
Sorry, I was just saying it appears that in many ways the president, in the way that William Barr has handled this today, is getting exactly the kind of Attorney General he wanted.
In a way, except for the fact that we are all able to read all of this, George. I think that one of the significant things here is that Barr has released this report the way he's released it. There was nothing here that was redacted, it seems, for the purpose of expressly protecting the president. We are seeing chapter and verse things the president did that in the eyes of the special counsel raised very serious questions of obstruction of justice. Perhaps what is especially interesting here is that you had Don McGahn and Jeff Sessions, especially, and others around the president, who stood up for the rule of law in the face of what they were being asked to do by the president himself. These were top advisors, appointees of the president, and they felt that the president was asking them to do things that was not consistent with the rule of law, and they did not comply with those orders. But one other thing I think I don't want to lose sight of in this report is we're talking a lot about the obstruction of justice case. There's significant material in here that we did not know on the question of collusion. Now, of course, if there's no finding that anybody in the Trump campaign was guilty of a criminal conspiracy in terms of dealing with the Russians on this, but the chapter on collusion shows significant contact between people on the Trump campaign and with the Russians. Take a look at page 33 dealing with the Russian disinformation campaign that was a critical part of their effort to meddle in the election. The company, of course, is IRA, the Internet Research Agency. That's the Russian company that was doing this. And Mueller writes, posts from IRA-controlled Twitter accounts were cited or retweeted by multiple Trump campaign officials and surrogates, including Donald Trump Jr., Eric Trump, Kellyanne Conway, Brad Parscale, who's the chairman of the re-election campaign, and Michael Flynn. There was even a section here where the president's personal account responded to a tweet from one of these Russian accounts. So the Russians were attempting to interfere with the U.S. election in part by spreading disinformation through this internet company, and they were finding some cooperation on the part. Maybe it's unwitting cooperation, but they were getting helped in that effort by people on the Trump campaign who were further disseminating this disinformation coming directly from the Russians.
And one of the points that may be made there, because he does seem to, Robert Mueller, from what we've seen so far of the report, to hang a lot on the fact that they didn't knowingly engage in this, that perhaps members of the Trump campaign were protected there from their own inexperience and ignorance of the law.
Yeah, not realizing that what they were doing was directly coming from the Russians, and if they did, not realizing that this would be a violation of the law. The violation is that a presidential campaign cannot accept something of value from a foreign source. And ultimately, the conclusion here in the special counsel was it did not rise to the level of a violation of the law, but there is significant contact here. You might even say collusion, George, because again, collusion is not the crime. The crime is a conspiracy to break a law. But there is significant contact between key members of the Trump campaign and the Russians.
And that brings us back to Celia Vega on this point. Throughout the election, from the days immediately after the election, what we heard from the president and his team again and again and again, there were no contacts with Russia. We now know there were at least 100 contacts with Russia, and clearly, had all this information been available in real time, a very different world.
It was one of the, if not the first question I ever asked then President-elect Donald Trump at that press conference he gave right after the election on the ground floor of Trump Tower here in New York City. Did you or anyone on your team have contact with the Russians? And he turned back to me and said, no, absolutely not. We now know that to not be true. I'm struck, as I think are many journalists covering this right now, by the fact that this report validates much of the reporting that we've been reading and doing here at our own network and at among our competition in the newspapers as well. It really raises some, I think, credibility, big questions for the White House going forward about what we can and can't believe out of the press shop there when they've strongly refuted stories that we now know to be true. The president's involvement in that Trump Air Force One statement after involved in the Trump Tower, whether he or not he was involved in the statement that was written on behalf of Don Jr. If you remember that, it was such a big brouhaha back then. The White House had said the president had no involvement in that statement, and Robert Mueller says he was heavily involved. In fact, he helped write it himself. If I might, George, point out to our audience, page 236 in the second section, it gets at the president's mindset. He says several advisors recalled that the president-elect viewed stories about his Russian connections, the Russia investigations, and the intelligence community assessment of Russian interference as a threat to the legitimacy of his electoral victory. He cites Hope Hicks, who says that that this was his Achilles heel, that the intelligence community's assessment that Russia had interfered with our election was President Trump's Achilles heel. They quote Sean Spicer, who was the first White House communications director, we all remember, who recalled that the president thought the Russia story was developed to undermine the legitimacy of his election. Aide after aide, Gates, former chief of staff Reince Priebus, recalling that the intelligence assessment came out when it came out, the president-elect was concerned people would question the legitimacy of his win. So as we go through these 400 pages and we wonder why and how all this could have happened, it's because the president was so very directly threatened by this investigation that was happening.
That Ken Starr, and Kate and I were talking about this before, Ken Starr viewed it as an impeachable offense that the president lied to the public about certain facts on Monica Lewinsky. Now, Congress didn't end up taking that up, but the point is that there's a lot of evidence now that the president and his team lied to the public.
But that's a significant difference between the laws they were working under. Ken Starr was required to report to the Congress.
Yep, that's right. But there is a secondary way to read this report that will be done in the coming days. The first is, okay, well, what are the facts that were produced about collusion, conspiracy with the Russians, and obstruction? The secondary way is, how many times did he lie to the American public? Yeah. Because these are the words not of anonymous sources, Don McGahn. Right, his own lawyer, Hope Hicks. I mean, I was just reading the passage. It's on page 71 of the second section, where in really what was a shocking move to many people, the president had the foreign minister of Russia and the Russian ambassador into the Oval Office, a security nightmare, many people thought, and supposedly said, Comey's off my back, he was crazy, got all the pressure off of us now, and So the White House never formally denied it, but kind of pushed reporters away from that. Don McGahn testified to it right after the meeting. He talked to the president about it. And it was confirmed. That's what the president told the Russians. Now we can do business.
That will be one of the big questions going forward. Again, a lot of this, as Cecilia pointed out, has been reported before, absorbed, it appears, by at least parts of the American public. Will take on a different character now that it's been ratified by the special counsel. I want to bring Chris Christie back in because, Chris, as I say, you're a former prosecutor as well as a former governor of New Jersey, and you wanted to weigh in on this question, this section of why and how Robert Mueller chose not to reach an ultimate conclusion that the president obstructed justice.
Yeah, George, I agree with Dan's analysis earlier that that the OLC opinion plays even more of a role in it than was initially thought. And when you go back now, if you look at the report in the summary section on page 2, look at the third point. What he says in there is that the ordinary means for an individual to respond to an accusation is through a speedy and public trial with all the procedural protections that surround a criminal case. An individual believes he was wrongly accused can use that process to seek to clear his name. In contrast, the prosecutor's judgment that crimes were committed, but that no charges will be brought, affords no such adversarial opportunity for public name clearing before an impartial adjudicator. So I think what he's also saying here is another reason we didn't do it in terms of saying we thought he committed a crime without bringing charges is that we're tarring him without giving him a public forum opportunity among a jury of his peers to be able to clear his name. And the reason he can't do that is because he can't be charged under the OLC opinion. So I think the OLC opinion played a much more key role in Bob Mueller's determination than we were originally led to believe when you really carefully read page 1 and page 2 of that report.
Can I press you on that then? How do you explain the quite large difference between Robert Mueller and William Barr, saying that the OLC opinion had no role in his ultimate judgment that the president did not obstruct justice?
Well, I think there's the difference. I think it played a role in Mueller's determination, but didn't play a role in Barr's determination. Barr saying, I looked at the facts, and the facts as laid out by Mueller to me don't constitute a winnable obstruction case, therefore we're not bringing the case. I think what Mueller is saying is, even if I wanted to, I don't think I could. And the reason, because we're talking about why didn't he give an opinion in here? Why didn't he say, I think he did it or I think he didn't? And I think that third paragraph tells you why, if he believed that it was obstruction, he didn't say it. Because what he's saying is that would be unfair to the president because he doesn't have the opportunity, like every other person who's accused of a crime has, to be able to have a trial in front of an impartial adjudicator, a federal judge, and a jury of his peers to be able to present evidence to clear his name. And so I think that it may not have played, you have to take Attorney General Barr at his word, it may not have played any role in he and the Deputy Attorney General's ultimate determination about whether to bring those charges or not. But it seems to me from reading this, and the more carefully we read it, I think the clearer it is, that it did play a very large role, not only in whether he decided to charge or not, but almost just as importantly, whether he was going to opine on it or not, because he thought that would be fundamentally unfair to the president.
And Chris, let me ask you the question I asked Kate Shaw a moment ago. What does this tell you about, again, we've known that Robert Mueller spun off a lot of cases as well, including that Michael Cohen case in the Southern District. What does this tell you about the Southern District and any potential plans they may have with the president in the campaign finance case? Do they follow the same reasoning that Robert Mueller did?
I don't think they're going to have any choice but to, George, because it seems to me that now both Robert Mueller, impliedly, and Bill Barr explicitly have taken that position. And listen, having been a U.S. attorney, in a case that has national importance beyond just your own district, you are not going to bring charges that have, on a case like this, that have not been signed off on by the Deputy Attorney General and the Attorney General. And it seems to me from reading this, and this is speculation on my part, but it seems to me from reading this that there's no way they would get the approval of this Attorney General to bring those type of charges against the sitting president, given what we see in the Mueller report and what we've heard from the Attorney General.
Chris Christie, thanks very much. I want to go to Capitol Hill. Our senior congressional correspondent, Mary Bruce. You're at the White House right now, but you cover Capitol Hill. And clearly the big question now, it appears that, we've seen these prosecutorial judgments from Robert Mueller, from William Barr. We just heard Chris Christie's analysis of the Southern District. The key question now is, how does Congress read this evidence? What do they do with it?
Exactly, George. And there is a section here that I suspect Democrats are going to be digging into here. In particular, one line when you get into the section on obstruction of justice, where it says, we concluded that Congress has authority to prohibit a president's corrupt use of his authority in order to protect the integrity of the administration of justice. That gets at the question of what is Congress's role here when it comes to determining obstruction of justice. And as has been discussed previously by Terry and others, Congress has a very different mandate here. They aren't just looking at the question of criminality like the special counsel was. They are looking at broader questions of abuses of power and also at the president's behavior. Did he act in a way that was immoral and unethical? Does anything that is revealed in this report raise that question again of impeachment? It is a conversation that Democratic leaders have made very clear they do not want to be having right now, that they may never be ready to have in earnest. But when you read through this report, the question then will become, will we see more calls from rank and file members of Congress to at least engage in that conversation? Democratic leaders on the Hill, chairman of many of these committees, have made very clear that they feel that they should be the ones absorbing this report, absorbing the full report and the underlying evidence, and acting as the filter between the Justice Department and the American people. And they're going to be dialing down, especially on this question of obstruction of justice. It is why we are hearing from so many chairmen now saying they need to hear from Mueller directly, in his own words, in the coming weeks on the Hill.
Matthew Dowd, so much of that, thank you, Mary, will depend on the court of public opinion as well. And it gets to the question we were having just a couple of moments ago. What difference does it make now for Robert Mueller, for this essentially to be Robert Mueller's report? This not to be a group of stories in the New York Times and the Washington Post and ABC News and CNN, but it is Robert Mueller saying these are the facts, this is what the president was doing publicly, this is what he was doing behind the scenes. Does it crack already settled public opinion?
Well, that's a big question, but I think this lands, it lands with a much deeper weight than what has been discussed before, that what Bill Barr said or what was said in the New York Times. I think it's important to separate the two things here. One, we can talk about criminal liability of the president, which looks like it's settled here, but his political and congressional liability seems wide open for discussion. This is even on the question of collusion or conspiracy, this report mentions tons of contacts, numerous links, all of that can be investigated from the political and from the congressional. Tons of evidence on obstruction of justice. And then broadly, we have a president that was willing to lie, mislead the public, the press, and ask people to work for him to interfere in the election and lie on his behalf. That's a huge question that Congress is going to have to struggle with.
Congress is going to have to struggle with. One of the questions, though, Terry Moran, is one of the things we've seen is everything filtered through a partisan lens. And in past investigations of presidents, Richard Nixon didn't lose power until his party broke with him. Bill Clinton has significant critics as well within the party, but ultimately they voted not to convict. Right now, it does appear that the partisan lines are very, very deep, very hard.
There is no way, based on what we're seeing so far, that I could see the Republican Party breaking with this president, even with Nixon. It took Nixon's own voice on tape that the Supreme Court required be released to the public, saying, let's conspire to obstruct justice in this Watergate thing, for some Republicans finally to break with him and force his resignation. I think that there's a deeper possibility here. The Department of Justice decided that there won't be an indictment, a charge of obstruction of justice. Impeachment is a very difficult, properly so.
And conviction even higher.
Right, and conviction even higher. But does this begin to impact how Donald Trump is seen? This is not a pretty picture. It is a picture of a man who justifiably won an election, but as soon as the special counsel is appointed, he says, this is the end of my presidency, and starts fighting, sometimes dirty, or trying to get dirty. Let's fire this guy. Let's do whatever we can. But does this portrait of a man fighting, sometimes trying, perhaps, to obstruct justice, and certainly all, as Cecilia pointed out, all of the instances where this report demonstrates that President Trump did not tell the American people the truth. He called these reports fake news. They weren't. They were facts. And does that begin to wear at his public opinion?
And maybe I'm just on a personal level troubled by some of this because we're the ones who sit in the front row of these briefings when we had them or at the White House and pose these questions to the officials about the accuracy and the validity of the reporting that's out there, and they're denying them. And I'm just reading in this vein another section on page, what is the section 2, page 72. It's talking about the firing of James Comey, and it gets into some of Press Secretary Sarah Sanders' statements to the special counsel Robert Mueller. And they're going back to a press conference in May 2017 at a White House press briefing where she said that we had heard from countless members of the FBI that say very different things in terms of talking badly about James Comey. And I remember that. She's telling now the Office of the Special Counsel that was a slip of the tongue. She also recalled her statement in a separate press interview that the rank and file and FBI agents had lost confidence in Comey. She says that was a comment she made in the heat of the moment that was not founded on anything.
Not founded on anything at all. But it seems, Kate Shaw, that in some ways, even though Robert Mueller said the fact that you're doing it in public does not protect you, does not immunize you from any kind of criminal investigation, it seemed for William Barr, at least, that the fact that so much of this was public and perhaps politically as well is actually also protecting the president.
Right. I'm not sure how Barr would defend the legal relevance of the public versus private piece of it, but politically, I feel like it could matter, right? So it could, the fact that many of these things that we've heard some of these statements and some of them have been refuted, is the fact that there is inconsistency between witness accounts and presidential statements really going to be news to anybody? I'm not sure. Is it really going to move anybody? I'm not sure. But I do think, just to return to something that your question for Terry about sort of partisan lines, this is a small piece of maybe counter evidence, but I do think that the March vote in the House, unanimous vote to release the full report, that's a sort of significant show of bipartisan. Obviously, we're not talking about an impeachment vote. It's a non-binding, resolution. But I thought it had some kind of symbolic meaning that so many members of the president's party were willing to cross over and vote to release the report. So one tiny piece of sort of nonpartisan conduct.
And reflected in polls. You get 70% of Americans saying, yeah, release the full report. You can't get 70% of Americans, agreeing what day it is. And when I went to the rally held in Grand Rapids, just after the initial report was sent up to the Department of Justice, I kept asking people, do you want to see the whole report? And most people said yes, absolutely.
And they're seeing a lot of it. Wasn't too redacted so far. 448 pages. Been in public now for about an hour and a half. The Mueller report, 2 big sections on obstruction of justice and collusion. The Attorney General said he could not determine that the president obstructed justice, but Robert Mueller reached quite a different conclusion, saying that he had confidence that a thorough investigation of the facts that the president clearly did not commit obstruction of justice. We would so state. They did not state that. This, as we've been saying, this 448 pages also portrays a portrait of the president who, in many occasions, did not tell the truth about his contacts with Russia and was determined to try to have his aides around him interfere with the investigation, perhaps remove those in charge. We are joined now by the president's personal attorney, one of the president's personal attorneys, Jay Sekulow. And Jay, thank you for joining us coming out of this right now. Your first read on the bottom line conclusions of Robert Mueller is, if you had a chance, first of all, should I say, to go through the entire 448 pages, your team at least?
I have. No, we as Bill Barr said earlier today, under Office of Government Ethics Rules and Policy, we were able to see the report in a skiff at the Department of Justice on Tuesday and Wednesday of this week. We were not allowed to. We didn't interface with the Department of Justice. We didn't offer redactions. We weren't offering comments. It just allowed us to read it as part of the practice under the Office of Government Ethics as the subject of it. So I've had a chance. So of course I had a chance to review it. Look, I think there's 2 things. The big takeaways here are, number one, the basis upon which this investigation began, which was this concern over Russian collusion with the Trump campaign or people in the Trump campaign, was answered very clearly. Couldn't have been any clearer, and that is that there is, in fact, no collusion. And they were emphatic about that. And you could go through the various events there, and I know you have already on your broadcast, so I won't labor that point. But there's no question there was collusion. So that was no collusion. So you take the whole scenario together and say, okay, then they move to obstruction. So you don't have an overarching crime that was the beginning of this investigation, which was this collusion inquiry. There's nothing there, they said. No evidence of collusion at all. And then they moved to, was there acts that were obstructive? But I think what Bill Barr said today is very instructive on that point, and that is this was a president that was under a siege with this investigation that we now know dated back beyond Bob Mueller's appointment, but was this Operation Crossfire Hurricane back in 2016. He's been dealing it now for almost 3 years. And he defended himself, and he defended himself exercising his First Amendment rights. And that this idea that there could be obstruction by tweet, which is kind of the theory they were operating under, you read a portion of
Jay,
the conclusion about exoneration.
I have to stop you there, because you're right. That is the conclusion of William Barr. That is not the conclusion of Robert Mueller, and that's what I want to have you respond to. Yeah, I mean, he says, if we could determine the president did not commit obstruction of justice, we would so state. Did not determine that.
Well, read the next sentence, though. What does he say after that?
Based on the facts and applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude that the president committed a crime, it does not exonerate him.
Right. Well, a prosecutor, George's job is not exoneration. They either determine that there is a criminal act or there's not. They said in that letter, and that's why you got to read the whole paragraph, that they don't have evidence to show that there was a crime. And
no, that's not what they said. They said they did not conclude that he committed a crime, not that they don't have evidence.
Well, if you don't conclude, well, hold it. But, George, if you don't conclude the individual that's the subject of the investigation has committed a crime, you don't bring a charge. So what you got here, look, if they had an obstruction case, they would have made it. They did not. I call this a reluctant declination sentence. That's what that is. It's a reluctant declination sentence. But that's what it is. And so the legal theories they were operating under, and what the Attorney General said was, we will even take the legal theory that Bob Mueller was operating under, even looking at through that theory and applying the evidence, we do not find that there are obstructive acts that would warrant criminality.
Well, that was again Barr's conclusion, not Mueller's conclusion. I got to ask you about.
But George, to be fair, you cannot ignore that last sentence of that report. In that sentence, that paragraph you read, where it talks about not exonerating, if we could, if we would have, which was not their job, by the way, neither their mandate nor a job of the prosecutor, but you can't ignore that last sentence. Oh, no, I'm not ignoring it at all. We've said it several times. But another question, because there are sections in here where dealing with the president's pardon power, and I wanted to present this to you because it involves Paul Manafort, of course, who's been convicted now, and his deputy, Gates. And it says that in January 2018, Manafort told Gates that he had talked to the president's personal counsel, and they were, quote, going to take care of us. Manafort told Gates it was stupid to plead, saying that he'd been in touch with the president's personal counsel and repeating that they should sit tight and will be taken care of. Gates asked Manafort outright if anyone mentioned pardons, and Mueller said no one used that word, but they were saying, boy, we're going to get taken care of. And that seems of a piece with the sections that Robert Mueller has written about Michael Cohen. Yeah, and the thing is, there were no pardons given. With regard to the Paul Manafort discussion, Manafort, according to the report, said that no one discussed a pardon with him or his lawyers. And regarding the situation with Michael Cohen, all I'm going to say about that is read what the Southern District said about Michael Cohen, and that he blames everyone else. And so, Jim, and I've stated on the record and very clear that no one offered a pardon to Michael Cohen. And as part of the president's legal case. And the Paul Manafort's testimony that he told Gates that he would be taken care of? That was told. I have no knowledge of that at all either. I have no idea of what that is. And I think I don't know who that was made to in the context. I didn't have those conversations, and of course we won't disclose conversations that colleagues may or may not have. But I don't know anything about that. It doesn't sound like that matured to anything. But by the way, just to be clear, this whole discussion about pardons, it's not as if the president doesn't have a pardon power. That's plenary in the Constitution of the United States. He didn't exercise it. It wasn't on the table. He did not exercise it. And Jay, you can never take that authority away. That's a big part of your defense, correct? That the president, whether the firing, the Constitution, that the president was acting within his powers under the Constitution. Yes. Jay Sekulow, thanks for your time today. Thank you. Appreciate it, George. Bye. Now I want to get a Democratic perspective now from Congressman Eric Swalwell, member of the House Intelligence Committee. Congressman Swalwell, thank you for joining us as well. Your first reactions. I know you probably haven't had a chance to read all 448 pages, but your first reactions to what you have been able to read of this report.
George, I've gone through the conspiracy section, about 200 pages, and it's clearer than ever that the Russians attacked us, and there was a multiplicity of contacts between the Russians and the Trump campaign. And so first and foremost, we need a president who is going to acknowledge that we were attacked by Russia and assure us that this won't happen in the upcoming election. But also, as a member of Congress, just because there was a failure of imagination in the past to contemplate that conduct like this could take place doesn't mean we don't have a responsibility now to write new laws to protect any about the future as we standard. I don't accept that there's not evidence that they sought to work with the Russians. It's a high standard, and the report also found that the president in his campaign took numerous steps to lie and obstruct that materially impaired the investigation. But in America, George, if you bury the evidence deep enough so no one can find it, you don't get off scot-free. There are crimes of obstruction of justice, and this is a double-digit obstructor in that the Mueller report found 10 instances where the president sought to obstruct justice.
Well, that was the evidence he laid out, but Mueller did not reach the conclusion that the president did indeed obstruct justice. He had that even-handed, and I'm not reaching that conclusion. I'm not saying that he didn't. The question now is, for all of you members of Congress, what do you do with it now? Is the Judiciary Committee going to open impeachment proceedings?
The first thing we're going to do is bring Barr forward, but also we have sent out a letter today inviting Bob Mueller to testify. I think he will be, the final word on this, not Attorney General Barr, who, George, I am calling on to resign. I believe you can be the Attorney General of the United States or the President's lawyer, but you can't be both. And the way that he conducted himself to get this job, the failure to recuse himself, and the way he mischaracterized the report in the press conference shows that he's more interested in being the President's lawyer.
Specifically, though, how do you think he mischaracterized the report?
Well, I think he did not accurately describe the instances of obstruction of justice that was laid out by Mueller, and also he said there was no evidence of conspiracy, and the report laid out a multiplicity of contacts which was evidence of conspiracy. It's just not evidence that rises to the reasonable doubt standard. And so, again, it seems like he's embedded with the campaign, where legally I think he should be recused. It
appears that you're not going to get all of the information, all the underlying documents yet. Of course, your chairman, Gerald Nadler, has authorized a subpoena. Your committee has authorized a subpoena for those grand jury documents. Do you think that subpoena should be served and immediately?
I do. And, this is an investigation that we paid for. We should see as much of it as possible. Anything that's ongoing, and it's certainly clear that there's 14 open investigations as it relates to Russia that have been farmed out. That should continue to be redacted. But as far as the grand jury materials and the personal identifying information, I do believe Congress has an interest in seeing that, and then we can further protect persons if there's an interest in doing that. But we have an interest to do that, and that interest must be to protect against future interference. The only way to do that is to understand completely who worked with the Trump campaign on the Russian side and what reforms will be needed going forward.
Eric Swalwell, thanks very much. I want to bring Mary Bruce back in from Capitol Hill. It does seem like we have several steps now to go through on Capitol Hill. We're going to hear from William Barr on May 1st and 2nd to the Senate and House Judiciary Committees. Clearly, at this point, it does appear that Robert Mueller will be heard from as well. And then the whole question of whether or not they get the entire unredacted report and these underlying documents.
Yeah, and George, even before that, one of the first steps may be what you just discussed there with Eric Swalwell, which is seeing those subpoenas being served from the Judiciary Committee. We know that Chairman Nadler has said that he's prepared to use them in short order, possibly as soon as tomorrow. We are going to be hearing from the chairman later this afternoon when he holds his own press conference. But you are going to be then seeing these public testimonies. You're going to hear from Bill Barr before the House and Senate Judiciary Committees. Then you have the Intelligence Committees and the Judiciary Committee also now now asking for Mueller to come before their committees and testify. They want this full public airing. We still do not know, though, when you're going to see congressional leaders seeing that redacted version of the report that Bill Barr announced this morning that he would be providing to them, of course, with those exceptions for the grand jury material. We don't know when they're going to see that, but of course that's not going to cut it. Democrats are still going to insist on the full report and the underlying evidence, and George, they are willing to go to court to get it. So you're going to see these testimonies publicly from Barr and Mueller, but you are likely going to see ultimately a court fight here.
A long court fight. It could be quite a long court fight. One big difference, we could see Terry Moran from the Nixon case, where they did get the underlying grand jury evidence. In that case, both Congress and the administration went together to petition for that underlying material. That's not going to happen here.
Right, and there's also now this recent opinion by the D.C. Circuit, by the controlling appellate court, that says district judges can't just invent new exceptions to grand jury secrecy. Which threw a wrench in all kinds of...
Yeah, but the question is an impeachment proceeding, a judicial proceeding that would grant them the right to get the material?
That's a question.
That is the big question. Pierre Thomas, meantime, one of the things we've lost a little bit of sight of right now is the fact that Robert Mueller not only produced this report, not only produced the indictments we've seen over the last 18 months, but also spun off a number of investigations to other U.S. attorneys around the country, which are continuing.
George, there's some new information in this report that strikes us. There are at least 14 other possible criminal investigations that have been launched that were outside of the scope of the special counsel. 14. And in the report, they only identified 2 of them that we can see. Michael Cohen's investigation and the recent investigation that was announced involving Greg Craig. So there are at least 12 other spin-off investigations. So the aftermath of this investigation spawned by Robert Mueller will continue for quite some time, George.
It is going to go on for some time, and of course that's why some material is redacted from this right now. Dan Abrams. The analysis of this report has only just begun. The political impact has only just begun right now. There's a lot to wade through here, even though people on both sides have already reached pretty firm conclusions.
Yeah, and I think that you can start with the fact that it is true that it doesn't seem that there is any real evidence of the Trump campaign being involved in a conspiracy to interfere with the election intentionally. There's some evidence of unwittingly, but not intentionally, to interfere with the election, which was the fundamental basis for the investigation.
And a lot of willingness to meet with Russians, to talk to Russians, to get the information.
True, but on the fundamental question of interference with the election, the hacking, the Internet Research Agency indictments, there is no intentional link there. That's takeaway number 1. But takeaway number 2 and 3, I think, are more problematic for the president. Number 2, big picture, is there are a lot of people here who are saying the president is lying, has lied to the public about a lot of things, and that the president tried to end this investigation, that the president tried to fire people who he shouldn't have been trying to fire. And that's important when you're looking at this. And number 3 is the Office of Legal Counsel issue, which I keep coming back to, which is it is clear that when Robert Mueller looked at the evidence of obstruction, he looked at it through the prism of, I can't indict a sitting president, so what can I do? And that's why when people say it's not a prosecutor's job to clear someone, that's true. Except when the prosecutor is saying, I don't have the power to indict someone, I can't indict them, it then becomes a little more understandable what he means by, I can't exonerate him. So what it sounds like he's saying is, there's a lot of evidence here of obstruction of justice. He lays out all the different cases where it seems like there was obstruction, obstructive acts. But because a sitting president cannot be indicted, I don't have the authority to do that. I can't exonerate, but I'm also not saying that it's so clear-cut that I'm willing to go out on a limb and someone who can't respond to it, as Chris Christie was pointing out earlier, in this kind of a non-proceeding, I'm not going to say that this person did it either. So I think that's the big takeaway, which is that's not a great end result for the president when it comes to obstruction of justice.
Yeah, I mean, so So I think that the way the special counsel approached the task on obstruction is really important. And I was just looking at the way the special counsel report frames the conspiracy question. And in some ways, it's kind of narrow, too, right? So in the opening on page 2 of the conspiracy or collusion section of the report, they say, conspiracy requires more than two parties taking actions that were informed by or responsive to the other's actions or interests. So, yeah, maybe we did have a lot of Russian players and a lot of campaign operatives taking actions that were responsive to each other's actions and interests. Now, that's not enough to constitute any crimes that are chargeable beyond those that have already been charged for, related matters. But that also strikes me as a kind of implicit. We're not totally exonerating outside of this narrow legal framework kind of either. One other thing, since we've talked a little bit about the distinction between the legal framework we're in now with the special counsel and the old independent counsel law, so it was a response to, I think, a lot of sort of agreement about Ken Starr's overreach that led, I think, Congress to sort of revisit the independent counsel approach and the Department of Justice to come up with this, which is a sort of old version of the special counsel. I wonder whether coming out of this, there might be some kind of move to do something that sort of moves. Maybe we went too far from an independent counsel who had this unbridled authority and sort of reported directly to Congress to a special counsel bound by DOJ regulations reporting up to the Attorney General. Maybe there's something in between that gives a little bit more independence, but not the possibility of abuse.
Many more steps to get to before we get to that reconsideration right there. And Terry, what I'm thinking as I listen to both Dan and Kate, so much now politically and perhaps legally now going to hinge on how Robert Mueller handles that testimony when he goes before the Congress. As they point out, we got a lot of experienced lawyers at this table. A lot more will be looking at the report in the days ahead. But it is a nuanced, complicated argument. He is going to be asked to reach bottom line judgments. Do you think we should investigate or not? Should we impeach or not? Where does the evidence lie?
That's a big day, isn't it? When Robert Mueller, who has for 2 years investigated this most serious and dastardly attack on our election processes in history, and is going to be asked to deliver a bottom line. I think his bottom line is here in some ways, and it's that now is the duty of citizens. He did the digging. He decided, and the Attorney General decided that there wasn't the evidence for obstruction. He decided he wasn't going to bring a charge. So something different has to happen now, a conversation. 70% of the American people wanted to read this thing. Go at it. It's here. It's here online. It's going to be easy to get to. And in this special counsel report, he does say this. He says in there are rare cases where a criminal investigation of the president's conduct is justified. It's not saying this is one of them. He goes on to say, Congress may apply the obstruction laws to the president's corrupt exercise of the powers of his office, and that accords with our constitutional system of checks and balances. He's saying, and what he'll say in that day, is it's up to you, Congress, and it's up to the American people. I've done the digging. You decide.
And now the American people, that gets to the point, Cecilia Vegas, you pointed out, you work at that White House every single day. A lot of what we learned today in this report and will continue to learn in the coming days is stuff we've known before, but that the president has been able to blow right past with denials or simply changing the subject. The question now is, what kind of impact will it have now that Robert Mueller has reached these conclusions?
I think we are where we were when we started in some ways. This is yet another example of a Rorschach test. You will see this, and today one way, when the person sitting next to you may see it another. But the facts going forward this afternoon, tomorrow, and on out for this White House, for this president, for his aides, there are very serious questions about credibility. There are very serious questions about how far people went or didn't go in order to make the president happy or to ignore some of his wishes, and about whether people in that White House are comfortable with lying to the American public. Because clearly in this report, if we are to take it at face value, that happened on more than one occasion, on many occasions. Stories that we were told were not true, Robert Mueller says were true, right here in black and white. And so I think they've got some very serious questions to move forward. I also think Congress now has to have a conversation and take a step back to decide how much more of this the American public can stand and wants and what the appetite is going forward, because as we've heard from the president's team, it's very much case closed for them today.
And Mary Bruce, that is going to weigh on Congress. One of the things that, we was just talking to Terry about this idea that they can have a better chance of getting the grand jury information if they explicitly open an impeachment proceeding. But as we know, House Speaker Nancy Pelosi, up until now, up until the day of this report has been released, has been reluctant to take that step. The Democrats have not thought necessarily that that works politically for them.
Yeah, Democrats have made very clear that they think it is, so far, has been too soon to even be having a conversation about impeachment. They know that they're going to need essentially buy-in from the American public. They're going to need support from Republicans across the aisle, both politically and just logistically, if they ever want to move in that direction. And there is this bigger political question. Do Democrats run a risk of overplaying their hand here if they continue to dig into this? How aggressively will they dig into this? Of course, all of this is happening as we barrel towards the 2020 presidential election. And Democrats, of course, aren't just looking at the Mueller report. They're investigating this presidency on a host of issues, everything from the president's tax returns to his meetings with Russian President Vladimir Putin to his family's business interests. He is under an intense microscope on the Hill, and Democrats are having intense conversations about how to coordinate those investigations and how this should play out going forward. The question now is whether that I word, whether impeachment becomes more of a part of that conversation, George.
That is one of the questions. This is a big cultural conversation as well, Matthew Dunn. And I think one of the, in the past, we've seen these big reports come out of major national scandals, major national crises, whether it's the Starr report, whether it's the report coming out of the attacks in 9/11 or the Iran-Contra report back in the 1980s. And one of the questions I have about this report is, are we going to look at this and say, okay, this happened, these are the facts, and look at this issue from a commonly accepted set of facts?
Well, I don't know if we'll look at it from a commonly accepted set of facts. That's part of the problem in our democracy today, is we don't have a common set of facts. I do think a huge part of the country will look at it as a common set of values. And I think this discussion about the country's evenly divided, and it's divided, and one side will say this and one side will say that, that's actually not the portrayal of our country. There is a third of the country, 1/3 of the country, that is solidly behind the president. But there's a majority of the country that is very disturbed by this president. And this report is dropped in that environment. I think instead of problematic for the Democrats, who have to decide about impeachment, and Nancy Pelosi has already said, unless we have Republican support for impeachment, we're not going to move forward on it, which I think is a smart decision. Republicans have to figure out, and the president has to figure out, is though one small can of worms was closed by the delivery of this report today, there's a large barrel of other worms that have been opened politically for this president, and I think that's the problem for this president.
John Carl, one of the things we've also seen in past scandals is at least some admission of error or humility on the part of presidents, whether it was Ronald Reagan coming out of the Iran-Contra scandal. Bill Clinton even did apologize, even though he was also defiant at the idea of impeachment. I think there's little evidence that President Trump is going to change his stripes based on this report. He's already declaring victory. What is the big picture takeaway for the Trump White House today?
Well, the big picture takeaway is that this was an investigation into whether or not the Trump campaign conspired, colluded with the Russians in the effort to undermine our election. And the headline there is that they found no evidence of a direct conspiracy between members of the campaign and the Russians. And then on the question of obstruction, George, the bottom line here is that the investigation was largely allowed to run its course. In Mueller's assessment, the president's efforts to influence the investigation were mostly unsuccessful. And the fascinating thing about this report is the reason that Mueller says that the president's efforts to influence the investigation were unsuccessful. He said that is largely because the persons who surrounded the president declined to carry out orders or accede to his requests. So in other words, the president made efforts to interfere with this investigation. Those efforts, by and large, were unsuccessful.
And John,
they were unsuccessful because his own top advisors wouldn't follow his orders.
If you dial back the clock on that, I think we both remember those days when the president seemed most concerned. Had the president fired Robert Mueller in those days, given the situation he had on Capitol Hill, it could have been perhaps far more perilous than indeed this report has been so far.
Indeed, the president's top advisors protected him from himself. I think that is a bottom line conclusion of this report.
And Pierre Thomas, what does this mean for the Justice Department going forward? We've seen over the last couple of years turmoil at the Justice Department, internal and external turmoil. The president attacking his own attorney general, Jeff Sessions. You now have William Barr, who's come in, who had actually had a long-time relationship with Robert Mueller as well, to try and steady the ship. But now he is under fire from critics on Capitol Hill and elsewhere for acting like the president's lawyer today more than the attorney general, in their words. What is the takeaway for the Department of Justice? Where do they go from here?
George, as someone who's covered the Justice Department now for more than 20 years and who's covered this investigation every step of the way, this investigation stressed the Justice Department system in ways that I've never seen before. You had the President of the United States putting pressure on the Attorney General. You had an Attorney General of the United States, Jeff Sessions, under investigation by a special counsel, looked at for possible perjury. And Bob Mueller was the person asked to wade into all of this, figure it out. I can tell you the system has survived, but it's been stressed in ways I've never seen before, George.
The system has survived. One other remarkable fact, Pierre Thomas, before I let you go, and that's now been about, what, 704 days since Robert Mueller was chosen. We've read some of his words today. We still haven't seen him speak.
That's right, George. Remarkable. Nearly 2 years, the man has not uttered a public word. I've covered him for many years. He likes for his work to speak for him. He did in this case, George.
The report is out, 448 pages from Special Counsel Robert Mueller on the issues of collusion between the President Trump's campaign and Russia. He said they could not find evidence of a crime and obstruction of justice. Robert Mueller did not reach a conclusion on that. That will now go to the Congress. They are already saying they want hearings with Robert Mueller, with the Attorney General William Barr. Will impeachment proceedings follow? That question yet to be determined. We're going to keep on covering this all day long on ABC News Live, and of course a full report tonight on World News with David Muir.
This has been a special report from ABC News.